Hi, I'm Annie Fitzsimmons. I'm your Washington REALTORS legal hotline lawyer. And today I'm so grateful to be joined by Julie Black from the Department of Labor and Industries. Thank you, Julie, for being here.
Thank you for the invite, Annie. This is exciting to partner with you.
And we do actually consider it a partnership. I'm glad you used that word. Washington REALTORS reached out to the Department of Labor and Industries some months ago when one of our members had an unfortunate audit finding. And we realized that maybe there are some other firms out there who don't understand that they have a reporting requirement with the Department of Labor and Industries regarding workers' compensation. Is that right?
That is correct.
Can you tell us about that?
So I know it can get confusing for firms, but we view brokers as covered workers in the workers' comp system. So if you already have an L&I account and you have no brokers working for your firm, you're good. You're in good standing. If you happen to have an account with us, but you're not reporting your brokers, then we really want to talk with you and work with you. This is our opportunity to work and to do some voluntary compliance and partner with the firms that need to update their accounts.
Okay, so a firm, when you say have an account, a firm might have an account if, for example, the firm truly has employees, secretarial staff, or somebody like that who the firm has always considered an employee and has always reported workers' compensation for that person. Then they would have an account.
That's correct.
Okay, but they could have an account and be paying workers' compensation on employees without also paying workers' compensation on their independent contractor brokers. Is that right?
Right, and those are the ones we want to talk to that we hope reach out to us.
Okay, so let's talk about that, because even though firms don't think of their independent contractors as employees, Labor and Industries considers them as covered workers. Is that right?
That's correct, yes.
Okay, and so when we talk about firms having to report their independent contractor real estate brokers as covered workers, and firms, on the other hand, are saying, no, they are independent contractors, they're not employees, and for tax purposes, that's really important to the firm. Labor and Industry says, that's fine, we don't have anything to do with the tax reporting. Is that right?
That is right.
Okay.
That won't affect anything outside of the workers' comp coverage.
Okay, so firms need to be reporting their brokers as covered workers to Labor and Industries. What if firm management team is listening to this video and says, but we are not doing that? What should that firm manager do?
Then we want them to call us. We can be reached at 360-902-4817, and we'd be happy to get them connected either to an underwriter or help them with next steps. But what we're offering up at this point is the voluntary compliance opportunity of going back 4 quarters of reporting hours and paying premium for these individuals, and we are going to waive the penalty and interest as well. So it's really an opportunity to work together in partnership.
Okay, what if they don't make that call? What if they don't come into voluntary compliance?
Well, there's risk associated with that. First of all, they could randomly be audited, and if they are audited, auditors can go back up to 12 quarters and charge back premium, penalties and interest as well. So it's not advantageous to fall into that realm. It's costly for a business.
Okay, so to recap what you just said, because this is really important. If a firm comes into voluntary compliance, and they haven't been paying workers' comp for their brokers, but they contact you, they call that phone number, they take the steps they need to take, they come into voluntary compliance, then what you just said is that Labor and Industries will waive all penalties and interest except for the last 4 quarters. Is that right?
That's right.
But if they don't do that, and they are discovered through an audit, which I'm telling you that this issue came to our attention because of an L&I audit having a very serious consequence for a real estate firm in Washington State recently. If they're discovered through an audit, they're going to have 12 quarters of penalties, interests, and premiums to pay.
That's correct.
Okay.
Yes.
For all of the brokers in their firm.
That's right.
All right. That could be a huge number, right?
Absolutely. And we would hope that that's not an advantageous place to be for a firm. So that's why we want to work with the firms.
Okay. Let's. I want to cover one more thing then, because you just made me think of this. When we use the term workers' comp, at no point do we actually use the word insurance, but really another name for what we're talking about is industrial insurance. Is that right?
That is right, yes.
And so if we're talking about insurance, then does that mean if brokers are covered, that if a broker is injured, let's say they're out showing a piece of property and they break their ankle, could that broker submit a claim to Department of Labor and Industries for coverage?
Yes, and we would accept it. We would, if there's any time loss, they would be compensated at a certain percentage of their wages, and their medical would be paid for.
Wow. Okay. So then looping back for a second, we were talking about the consequences of not coming into voluntary compliance. What if a firm doesn't come into voluntary compliance and doesn't get audited, but their broker breaks their ankle and submits a claim? What happens then?
Well, that's the real unfortunate part. That would be definitely the claim would be allowed and accepted. An auditor would go out and audit that firm and would conduct an audit going back 12 quarters, including adding penalties and interest and the cost of the claim. So it would be a very costly event for a firm who was not in compliance.
Okay, so they would have to pay the 12 quarters, and they would have to pay the medical and lost wages potentially for that broker who was injured.
That's right, and penalties and interest.
So then, speaking of benefits, we've talked about the benefit to the broker now. If they're injured, now we know that an injured broker can submit a claim to the workers' compensation program. Are there benefits to the firm?
There are. It's a no-fault insurance, so it really protects the firm as well from being sued.
What does that actually mean then? Let's say the broker not out a piece of real estate. Let's say they're actually in the office, they fall down the stairs and they claim that the stairs were faulty and that's why they injured themselves. You're saying that the broker whose firm covers them through workers' compensation would be barred or prohibited from filing a lawsuit against the firm?
It would protect the firm from being sued.
That sounds like a win-win.
It is. It's a real good it's a great benefit to have. Great protection.
Great. Thank you so much for being here today to help us understand this. If I get questions on the hotline and I can't answer them, can I call you?
Absolutely.
Great, and I probably might need that phone number again so I can direct people back to that.
It's 360-902-4817 is our main line in Employer Services, and we'd be happy to help.
Great, thank you so much. Thanks to all of you for being Washington Realtor members. If you have questions on this topic or any other, please send an email to me, legalhotline@warealtor.org.